Hi everyone, welcome to my channel Lulu. I am trying something different tonight. As I'm in the midst of studying for my next exam, I thought I would read some of my index note cards and see what you guys think. So this is an index card booklet that I bought from the 99-cent store in the West Coast, and they don't exist here, and it's a shame. I wish I had purchased more because I absolutely love these. They came in all these like pastel-y candy colours. I've got a lavender, I've got a baby blue, and I've got this pink one. So let's start. This is for business law. I added a heart in poor attempts to make the subject less painful, but unfortunately it didn't do much. Okay. What are the preemption rights existing under Section 561, Company Act, 2006? I think it's the Companies Act, yeah. Existing shareholders have a right to be offered the chance to buy any new shares before they are offered to outsiders. They have first refusal, where shares are being issued in exchange for cash, nothing else, unless the company's articles may include preemption rights in non-cash consideration. What do the preemption rights under Section 561 Companies Act 2006 not apply? If shares are allotted wholly or partly for non-cash consideration, Section 565, if shares are held under an employee share scheme, if they are bonus share issues, or if they are preference shares, and this first one is unless a company's articles included. By the way, I'm using my mini microphone. Tell me what you guys think of the sound. What is the procedure to issue shares under the existing preemption rights? If these rights exist in a company's articles of association, a procedure usually is included. Most popular procedure is to send existing shareholders a letter of rights and invitation to apply for shares. Where these rights are defined by statute, the existing shareholders must be given at least 21 days to accept the offer. Otherwise, if rights are defined in the Articles of Association, a different time period may be given. What are the methods of disapplication of the Section 561 preemptive rights for private companies? Section 561 Companies Act 2006 allows a company with only one class of shares, by special resolution of shareholders or special provision in articles. Section 567 allows a company by including a special article. Section 568 provides preemption provisions in a company's articles will override statutory provision of Section 561, but 562 notice provisions will still apply unless also excluded. Special resolution for specified allotment. Section 551 authorizes directors to allot shares. What information needs to be included in a letter of application for shares sent by someone wishing to subscribe for shares in a private company? The name and address of the applicant, the number of shares applying for, type of shares they are applying for, price per share they're applying for, details of company are not relevant. What is the maximum period a company may grant its directors authority to allot shares? maximum period of 5 years. What is the meaning of equity securities in the Section 560 Companies Act 2006? Equity securities means ordinary shares in the company or rights to subscribe, convert securities into ordinary shares in the company. What are the preference shares? Preference shares, aka preferred shares, which are shares with dividends that are paid to shareholders before common stock dividends are issued. If company goes bankrupt, preferred shareholders are entitled to be paid out before ordinary shareholders. Most preference shares have fixed dividend, do not hold any voting rights. 4 types of preferred stock: cumulative, non-cumulative, participating, convertible. What information should be included in an ordinary resolution giving authority to directors to allot shares? The maximum number of shares that may be allotted pursuant to authority, the date on which authority will expire. What is the effect of Section 550 Companies Act 2006? A private company that has only one class of share no longer requires shareholder authority for any allotment of shares. It cannot be used by public companies. Private companies incorporated before the 1st of October 2009 can only apply Section 550 if it passed an ordinary resolution to this effect. What is the effect of Section 551 Companies Act 2006? Where if Section 550 does not apply, then Section 551 says the company's directors may exercise the power to allot shares and grants rights to subscribe for, convert any security into shares in the company. Authority is given by ordinary resolution or in company's articles. Authorization must state a maximum number of shares. Authority cannot exceed a period of 5 years from date resolution was passed. In relation to a proposed allotment, all companies can disapply the statutory preemption procedure imposed by Section 561, Companies Act 2006. True or false, and how? True. Section 569 to 571 allows them to do this. Can be done by special resolution or provision in the articles. Private limited companies can exclude the effect of Section 561 Companies Act 2006 permanently by provision in the articles. True or false? True. Section 561 Companies Act 2006 allows this. What is an LP? What are some characteristics of an LP? An LP is a limited partnership. An alternative to a partnership formed under the Partnership Act 1890. Limited partnership is governed by Limited Partnerships Act 1907, not the same as a limited liability partnership. Has 2 types of partner: general partner, limited partner. No separate personality from its members. Must have at least one of each type, provided in Section 4 of the LPA 1907. For an limited partnership to exist, the definition of a partnership in Section 1, Partnership Act 1890 must be satisfied. What does Section 1 Partnership Act 1890 say? Defines partnership as the relation which exists between persons carrying on a business in common with a view to profit. FYI, an agreement for a limited partnership may modify or exclude any provision in the 1890 or 1907 Acts to the extent permitted by them. What is a Section 24 Partnership Act 1890? Sets out partners' management and financial rights which apply in the absence of a contrary agreement. There are a set of default rules implied into a partnership. Some of the rules provide that partners are entitled to share equally in the capital and profits of the firm, are entitled to take part in the management of the business, and can agree on matters connected with the business by majority. What is contained in Section 7 of the Limited Partnerships Act 1907? Provides that the Partnership Act 1890 and the rules of equity and common law are applicable to partnerships, shall apply to limited partnerships to the extent they aren't inconsistent with the Limited Partnership Act 1907 terms. When is a limited partner liable for the firm's debts and obligations? If the firm isn't properly registered, then they are a general partnership and all partners will have unlimited personal liability until correctly registered as a limited partnership with Companies House. If they take part in management of the firm in the same way as a general partner, or if they're personally liable to the extent that the partner is repaid its capital investment during the continuance of the partnership. There should be and, not or. I said or by accident. Section 5 Limited Partnership Act 1907. Every limited partnership must be registered. I wrote that twice. As such, in accordance with provisions of this Act, failure to register what is meant to be a limited partnership will render it a general partnership, and all partners will not have limited liability. Rainier and Company and Roads, 1926. Section 8C1 of the Limited Partnership Act, 1907, provides, on registering a limited partnership, the registrar shall issue a certificate of registration. Section 8C4 of the Limited Partnerships Act 1907 provides the certificate is conclusive evidence that a limited partnership has come into existence. Section 6.1 of the Limited Partnerships Act 1907 a limited partner shall not take part in the management of the partnership business and shall not have power to bind the firm. If he does, he'll be liable for all debts and obligations incurred by the firm while he takes part in the management as if he were a general partner. Section 4.3 Limited Partnership Act 1907. A limited partner shall not directly or indirectly draw out or receive back any part of his contribution, that is capital, and if he does, he'll be liable for all debts and obligations of the firm to the amount he drew out and received back. Section 9 Limited Partnerships Act 1907 During the continuance of a limited partnership, any change in the particulars listed in this section must be notified with a statement signed by the firm to company's registrar within 7 days of the change. Failure to register will be an offence committed by the general partners. Death and bankruptcy of a partner. Death and bankruptcy of a limited partner in a limited partnership in the absence of an agreement does not dissolve a limited partnership. Section 612 of the LPA 1907. Death and bankruptcy of a general partner in absence of agreement operates to dissolve the limited partnership. Section 33 of the Partnership Act 1890. Section 6.3 of the LPA 1907, winding up a limited partnership. General partners have a right and obligation to wind up a limited partnership on its dissolution, unless court orders otherwise. Section 4 of the LPA 1907 requires two types of partner: one general partner, one limited partner. If a limited partner takes back capital, his limited liability will be removed. That is like what the other index card said about withdrawing and receiving back capital. Like anything that he contributed, he'll be liable for if he takes out or receives back. What is an LLP? What are some characteristics of an LLP? An LLP is a limited liability partnership, not to be confused for limited partnership. Limited liability partnerships are a hybrid between a company and a general partnership. Changes in membership does not affect continued existence of an LLP. They own its own assets and business, liable for its own debts, liability of members limited to the amount they contributed, Section 74 Insolvency Act 1986. Members are responsible for paying tax on their share of the profits and gains generated by the LLP. What is Section 74 Insolvency Act 1986 modified for LLPs? When an LLP is wound up, every present and in some circumstances past members will be liable to contribute to the assets of the LLP if it is going into liquidation, and is liable to the extent to what he agreed to contribute to its assets. Past members shall only be liable if the obligation arising from such agreement surpassed his ceasing to be a member of that LLP. Section 6.1 Limited Liability Partnerships Act 2000. Every member of a limited liability partnership is the agent of the limited liability partnership. That means they are the agent of the LLP and not the co-members. How do you register an LLP? Application form must be filed with a fee. On the form, at least two of the members can be nominated as designated members. They are responsible for ensuring LLP complies with statutory obligations. Upon registration, Companies House will ensure all legal requirements are complete and issue a certificate of incorporation as proof the LLP has been properly formed. Any agreement is confidential and need not be filed with Companies House. What are some characteristics of an LLP? Limited liability partnership. Changes in membership do not affect continued existence. It owns its own assets and business, liable for its own debts. Actually, I think we went through this already. Members' liability is limited to the amount they agree to contribute. Members act as agents of the LLP, not for co-members. We went through this again. More characteristics of an LLP. An LLP must have a registered office. They can create floating charges over its assets. Terms affecting the relationship between members remain confidential. Members' agreement is a private document, does not have to be filed with Companies House. Accounting and filing obligations are much the same as in a company. Well, that's all for now. Please tell me what you thought of this type of ASMR video. I thought it would be helpful for some law students, or boring for some people who aren't in law, but a good kind of boring to hopefully fall asleep. Anyway, take care and have a great night.